Alexis Garcia for the department.
Richard Saldivar for the mother, Ms. Mcneill. Ms. Mcneill, will you announce, please?
Hello, I'm Janice Mcneill, or Janice Juan, mother.
Deborah Fuller, attorney ad litem for the child.
Sarah Woods, Hill Country Casa, guardian ad litem case supervisor.
Myra Cueva, CPI investigator.
Kristen Evans, CPI supervisor.
The whole truth and nothing but the truth, so help you God.
I do.
All right, thank you. Before we begin, I see that Ms. Juan is on a phone that says Debbie McNeil.
That's my aunt, Your Honor.
Okay, is that the Debbie McNeil that knows me?
That is, yes, sir.
Hi, Debbie.
How are you?
I'm well. How are you?
I'm good.
Hello. Before we begin, I want to make sure everybody knows that I do know Miss McNeil. I have worked with her in the past when I was an attorney. I need to know right now if there's going to be any issue, if she's affiliated with this case, if there's going to be any concerns or conflicts before I begin the hearing and engage in this at all.
I don't see any, Judge. Ms. Juan, do you see any conflicts, Ms. Juan?
I don't believe there's anything to be conflicting about, so no.
None from us, Judge.
And Your Honor, for the record, I was involved with the biological mother as a CPS attorney, and I did terminate the biological grandparents' rights to the biological mother many years ago. So I don't think it's a conflict, but I needed everyone to know that.
Okay. Ms. Garcia?
No objection, Your Honor.
Okay. And for the record, if nobody's opposed to Ms. Fuller continue, I don't have an issue with it. My association with Ms. McNeil was professional based on civil issues, completely separate from this. So I don't have any bias. I don't see any problem with me being fair and impartial in this case, but I wanted to make it known on the record that I do know her and I have worked with her in the past. So as long as everybody's okay proceeding, if at any point you're not, you need to let me know. Otherwise, I'm going to go ahead and proceed. I don't feel like it's enough of a reason for me to recuse myself at this point. Okay, then with that, do you all have an agreement?
Yes, Your Honor, there is agreement amongst the parties.
Okay, could you state the terms and conditions for me, please?
Yes, Your Honor. So the agreement is for the department to continue joint managing conservatorship of the child, for services to be assessed at the family group conference. There's also an agreement to have visitation be determined based on therapeutic recommendation between Ms. Juan and the child. And the department will make efforts to accommodate whether there can be family visitation depending on the facility's availability.
Recommendations on visitations depending on facilities availability. Is that what you said?
The visitation for other family members, whether they can accommodate multiple family members. However, we're asking for a therapeutic recommendation for visitation between mom and child in regards to the amount of hours and time and frequency.
I got that. I just didn't hear that last sentence, but I think I understand now. Okay. Any other terms and conditions?
That's it, Your Honor.
Is that your understanding of the agreement, Mr. Saldivar?
Good. I just want to clarify for mom's visitation. She's visiting now. I don't think there was any disagreement on her continuing an open visitation with the child, especially because I think the child wants the visitation now at placement. I think that it was more geared towards if the therapist makes a recommendation that they need to limit some contact based on progress or something like that, then we would be open to discussing that limitation on visitation. But I don't want it to come off as like she's limited now until the therapist says she can visit. That was my understanding of it. So if there's any confusion on that, I think we might have to have brief testimony, but I think that's kind of what I took from it and what Ms. Juan was taking from it as well.
No, that's correct. Mr. Saldivar, that's correct.
Okay, so then just so I understand, visitation is going to continue as normal, but if the therapist has another recommendation, court's going to take up the recommendation.
That's correct.
Okay.
Yes, Judge.
All right, Ms. Fuller.
The only other issue, Your Honor, I agree I have an agreement with all that, but my client has requested that she have contact with her siblings. She hasn't seen them in an extended period of time. And so I am requesting supervised contact with the siblings in a supervised setting.
Any objection?
Yeah, yes, they
Um,
objected.
Yes, Your Honor. The department's objection would we would just ask that those visitations would be based off of therapeutic recommendation, meaning those would start when a therapist has signed off on that.
It's same here, Judge. The children haven't seen each other for a while. My client's just concerned that throwing them back into visitation might cause some issues. So we're just looking for a therapeutic recommendation before that starts.
All right, Ms. Fuller, is your request for that solely based on your client's request for it?
Well, I mean, I also feel that sibling contact is important. I mean, it's going to be supervised and it's going to be in a controlled environment. And she feels abandoned to some degree, and she already has a RAD diagnosis. So I think that it's important that she understands that they're, the siblings and people in her family still want to be a part of her life.
Help me understand, Ms. Garcia, the department that belongs trepidation about that contract right now.
Yes, Your Honor. So it's very similar to what Mr. Saldivar said, just in the fact that they have not seen each other in 9 months. There are some behavioral issues when it comes to siblings, and we would just ask that the child be eased into that visitation from not seeing each other for 9 months to having visitation right off the bat. We would just ask that it be eased into. We're not in objection to the visitation as a whole. We would just ask that for therapeutic recommendation before that starts.
That's the same argument, Mr. Saldivar, or something else?
Same argument, Judge. And I don't know if Ms. Juan wants to just chip in on this in such a joint case, but I know the other children aren't a part of this suit, but it also affects their environment, their mental status and stuff. So I'd like the court to consider maybe family therapy. If the therapist for the current child in placement says that she's ready to go, then maybe also have a family therapist involved with all the children to see if that's appropriate, and then kind of guide them to start building that relationship again. Because again, it's been 9 months, and I understand that the children want her home, and so if they see her right away, that may cause some issues in the home. So and Judge, I'd like, if Ms. Juan wants to just add on to that so that you know what the concerns are, I'd like her to address that as well.
Yes, I would like to add on if I could.
Yeah, you can. I just know that I've read the affidavit and I know a lot of what's going on. So you can just hit the highlights for me as to why you think that you need to wait or you need a therapist recommendation.
Basically, the children that she was in the home with are her biological siblings. There has been a lot of mental and physical abuse throughout the years. Since she has been placed outside of the home, it is the only time that they've actually came to me expressing that they feel safe. They have expressed their feelings of loving her and wanting her as a sister, but not wanting her to return home because basically they feel unsafe or they're worried that she's going to harm somebody, or one of the children even said that they're not going to be strong enough to keep her from manipulating or bullying them. Academically, they have just soared and went from the very, very bottom of their class and their grades, barely making it by, to being, A honor roll and skipping grade levels in different areas, not actually bumping grades, but going from, third grade reading level to fourth grade when they were in like a academic probation kind of setting the year before. They do love Mally, but they have also expressed that they're not comfortable with it, and they're scared for seeing her again. But it's not that they don't love her or want to eventually see her. I think they fear that it's going to happen again, because honestly, with her diagnosis, there's no promise that it won't in the future. And I really don't want it to jeopardize the progress that they have made.
All right. Let me hear from is it Miss Perez, or is your last name different? Are you just signed under Perez?
It's Cuevas. It was signed on a different.
Okay,
Cuevas.
Cuevas, all right. Can you tell me what your opinion is based on your knowledge of the case with this contact that's being requested by the ad litem? You were unmuted and now you're muted again.
So when I met with the siblings at the school, I remembered mom did requested for me to not do like a full interview based on their past traumas. She did disclose to me that they love their sister. However, since she's been out of the home due to the last incident between Melissa and Cohen, the sibling, and the police was involved, she pretty much didn't want them to have any type of contact until Melissa was kind of like better. For them to kind of like heal and start that process. She did told me that she was interested in possibly family counseling, but her main needs were kind of like trying to see where Melissa can find the help that she needed.
Okay. Thank you, Ms. Cuerpos. What's CASA's take on this?
CASA is aligned with the department right now. Normally, I am all about sibling visits, but I think there's some safety concerns right now. And I do agree with Ms. Mcneill that we do need to ease everybody into this. 9 months is a long time not to see your siblings. And I think going straight into that would be a culture shock for everybody.
Okay. Ms. Fuller, any rebuttal to any of that?
I mean, I just feel it's important. When I spoke with her, that was her biggest concern. She told me on Sunday that she hasn't had any contact with anybody, with her mothers, with her siblings, with since she's been there. And so that concerns me. And I really feel like she needs to, I mean, she feels abandoned. And I think she needs to get services, but I think it's important to know that she's able to see her family. She hasn't been able to.
I can certainly understand that. I think I want to hear. I'm looking at the pleadings right now.
Your Honor, I do want to say that I have had contact with her since she's been in placement at this RTC, and I was in contact with her when she was in the behavioral health hospital and did plenty of visits there. I was not able to contact her till I was given the appropriate contact information at her current placement. But since I got that contact, I have been talking to her every night.
Okay. Thank you, Ms. Juan. Is there anything else outside of that you wanted to report to the court, Ms. Fuller?
I mean, Ms. Juan suggested looking into Meadowlands because Melissa had went to school, the charter school there. So I mean, I would ask that Belong look into that placement. She's in a facility that's only been open 2 months. And it has been a little difficult to get information from them. So if she's already used to the charter school at Meadowlands, and if they have an opening and if she qualifies to be there, I would ask that Belong look into that.
Okay, thank you. And Ms. Cuerpos, you did discuss prior to the department filing suit, the idea of the option of the joint managing conservatorship with Ms. Juan.
Yes, we did. And also the staffing supervisor, the covering supervisor had a conversation with mom as well.
Okay. You believe that this order would be necessary, considering the circumstances, that there's no other way we can do this?
Yes, I believe so.
Okay. Anything else that you're requesting today, Ms. Garcia?
No, Your Honor, nothing further.
All right. Ms. Cuerpos, do you believe that the department made all necessary reasonable efforts to avoid a removal?
Yes, I do.
And do you believe that the reasonable efforts that were made were consistent with the circumstances and provided for the safety of the child to eliminate or prevent the need for the removal?
Yes, I do.
Do you believe that the department has made all reasonable efforts to allow the child to return home, but there's a continuing danger or substantial risk of continuing danger if the child is returned home?
Yes.
All right. And you believe there was a danger to the physical health or safety of the child?
Yes, I do, which it was her own mental health.
All right. Anything else from CASA?
No, sir. We would like for sibling visits to start at therapeutic recommendation. And Ms. Juan did mention, which I think is a good idea, that Melissa have the opportunity to be a pen pal with one of her friends from school. I think that'd be a great option for her to have some community.
Okay.
With the recommendation from the therapist, is the well-being and the well-being of the other children going to be considered?
Well, and that's obviously what we would be looking at, Ms. Juan. I want to make sure something's very clear to you as we move through this case. So this is a joint managing conservatorship case. That's what the order is going to be, but it's still a child welfare case. It's still a case that has been initiated by the Department of Family Protective Services. We're having a hearing. So I'm going to make some orders that in some ways are going to sound somewhat adversarial, but I just need you to understand this is the only way we can do what it is that needs to be done. But the understanding is that you and the department and then the other professionals involved, the goal is to get Melissa the help that she needs. Okay. And to do that in a way to where we have the resources available to us through this system. It is going to require some work on your part as well. And what's going to happen after this hearing, after I make my ruling, is there's going to be what we call a family group conference. And at that family group conference, the services that are set forth are going to be predominantly in the best interest of getting Melissa the help that she needs. But there are also going to be some services and things that you're going to be required to do. We have a year to do that. And that year started March 21st, 2025. And that year is going to end March 23rd, 2026. Hopefully it won't take that long, but you'll have to be patient and work with the department through this process, just like everybody else is going to have to work through the process too. What I can tell you what I've encountered both as an attorney in these cases and also as a judge presiding over them is sometimes it seems to the parent that things aren't being done the way they want them to be done. I need you to understand that you've got to communicate with your caseworker, you've got to communicate with your attorney, with CASA, and Belong, who's going to be doing the conservatorship part of this, to make sure that you're working just as hard as they need you to work, so that whatever services Melissa is receiving, you're receiving the services that you can use to help you do things appropriately for her, maybe tools that you didn't know of beforehand. So I'm going to make a ruling here in a minute that's going to sound like I'm ordering you to do things, which I am, but it's in a joint managing conservatorship effort to do what's best for this child. I say all of that to make sure you understand the overriding interest in this case is what's in Melissa's best interest. So there may be times where orders may be made that don't necessarily take into account the best interests of your other children in the home. That's not to be difficult, and that's not to make it sound like they're not important. It's just that the child before this court is Melissa. And so the orders I'm going to be making are in Melissa's best interest. Does that make sense?
Yes, Your Honor.
Okay. Now, I in no way, shape, or form want to do anything that's going to harm any children of the family who are not before this court. So I need that information, but I just need you to understand that's the rubric I have to operate under. Okay? So you're welcome. All right. So for the purposes of the adversary hearing, the court will find that the mother, Ms. Juan, was served on March the 24th, 2025 by personal service. She's appeared here with her attorney. Ms. Juan, are you able to afford an attorney to represent you in this suit?
No, Your Honor.
Do you have anything you could sell or any assets you could liquidate that would allow you to pay for an attorney?
Maybe like old play equipment, but that would be about it.
Okay. So are you receiving any type of governmental assistance at this time?
No, Your Honor.
Okay. Is it your testimony to the court that you cannot afford an attorney to represent you in this case?
Yes, Your Honor.
All right. I'm going to find that Ms. Juan is indigent for the purposes of this case. I'm going to continue to have Mr. Saldivar represent her. Ms. Cuerpas, is there any Indian child heritage in this case that you're aware of?
No.
Okay. Court will find there's no Indian child heritage in this case. Court finds that the parties have entered into an agreement for the Department of Family Protective Services and Ms. Juan to be joint managing conservators of the child, Melissa Mcneill. Court finds that's in the best interest of the child. Court finds that the agreement includes that the parties will hold a family group conference and determine which services are necessary to proceed in this matter. Court finds that the parties have entered into agreement for visitation to be determined based on therapeutic recommendation between the mother and the child. I want to make sure that the order states that the visitation that's occurring right now shall continue subject to any therapist recommendations. So I'm not changing what's happening right now. I'm just making sure everybody's on the same page that it could change based on therapist recommendation. The recommendations will also be made as far as visitations of other family members, and that will be based on the ability of the facility to accommodate those visitations. Court understands, and I'm making orders based on those findings as stated. Court understands that the child, Melissa, would like to have visitation with her siblings at this time, based on the testimony provided in the best interest of the child. I'm going to order that those visitations be based on therapeutic recommendation as well. So we're not going to have any visitations between the siblings occur until a therapist has weighed in on what would be appropriate. I'm also going to order that Melissa be allowed to have a pen pal option as stated by Ms. Woods. I do want her to have some contact. I don't want her to feel completely alienated. We'll have our status hearing May 14th, 2025 at 9:30. May 14th, 2025 at 9:30. For the purposes of the requested relief, I do have to make the findings that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal, and reasonable efforts have been made to enable the child to return home, but there is a substantial risk of a continuing danger if the child is returned home. Again, I understand this is a joint managing conservatorship case. There's a reason I'm making those findings in this case, and it has a lot to do with funding. All right. We're going to come back, like I said, ma'am, on May the 14th at 9:30 for a status hearing. And at that status hearing, I'm going to hear how the child is doing, how you're doing, and what services were ordered at the family group conference. And I'm going to decide which ones to make orders of the court. I have to admonish you, and I already kind of told you, we get a year for you to demonstrate that you can provide the child with a safe, stable, violence and drug-free home. Obviously, we're not looking at this like we are at some of the other cases. This is joint managing, and you're just working along as well as she is. But I just want to hammer home that point that there is a time limit on this, and we have to get everything figured out within that time limit. Okay. Hopefully we can get it done a lot faster than the time allotted, but that remains to be seen. A lot of that depends on Melissa's progress. Miss Garcia, anything I failed to address at this time?
No, Your Honor, there's nothing further. Thank you.
Your
Okay.
Honor, I had another issue. I noticed that the child caregiver resource form was left completely blank. I would ask that it be filled out. And I wrote this down, and maybe Miss Juan can help me. I'm not exactly sure what it was. A Bitsy video game that she wanted. If that makes sense.
Sorry, it's a little toy.
Okay. That was the only other thing that I couldn't read my writing, so.
I've had that problem. Okay, I'll order that Miss Juan fill out the child caregiver resources form. That could come in handy. And then also order that the child get the Bitsy video game. If that's something that's going to make her feel more comfortable, we need to do it. Subject to whatever the facility thinks is appropriate, obviously. Okay, well, thank you all for your time and your service. I'll see you May 14th at 9:30. Nothing further. All parties are excused. Thank you. Good to see you again, Ms. Mcneill.
Thank you, Your Honor.
You're welcome. Thank you.